Good morning. I appreciate the opportunity to speak with you today. There's already some misinformation out there, and I want to correct it at the start. I'm not very shy. So, I do appreciate your coming here today on one of the last few days of the winter with spring, feeling like it's closing in on us. Thank goodness, after our early snowstorm in mid-November, I thought with 70 degrees earlier this week that we'd probably have an empty room today, but fortunately the weather's a little cooler and I appreciate you being here. As we go along, you're welcome to pose questions to me. Help me remember, please, to repeat them because we only have one microphone today. I would ask you to let me get a little ways into our material, the substance of our material today before the questions begin, just to let us get a sense of all of our being on the same page, please. While our topic in the narrowest sense, or our topics involve primarily the subject of mediation, and I assured Ms. Briscoe and Ms. Smock that I would comment on arbitration as well. I want you to travel with me back a little ways to an incident I was involved in a case I was handling with a young lawyer to help him with it a year or two ago. And it was a dispute of substance. There was a lot of money involved. And we had to take a deposition of a witness in Massachusetts. And that witness had earlier been actually in one of the local counties. There were people here from the county where this dispute arose. But this witness, who actually had resided in suburban Washington, had changed jobs and moved to Massachusetts. So we had to go up there to take her deposition. And we worked hard to prepare for it. We had a stack of documents, literally a couple of feet thick. It was a complex problem. And the witness was not favorable to us, not by just the structure of the case. We knew this was likely to be a challenging deposition. So we prepared heavily before we left. We carried all these documents with us as exhibits to the deposition. And having taken a lot of depositions through the years, I anticipated that what would happen was that the witness would, within minutes, immediately spout her and her organization's position on the record, and that's exactly what she did. So we started the deposition. We're in a hotel conference room, not unlike this, but a little smaller, and immediately the witness stomps on our case, in effect, by reciting a series of points favorable to the other side. And my colleague, of course, is wincing over there. Well, I knew that was likely at some point to come along, and probably sooner rather than later. So we took a recess after a little bit, and he's a real fine lawyer, but he was concerned about what was said, and I said, well, don't forget, we've got the goods. And the goods were this 2-foot stack of documents that we had, a number of which had come from the organization and from this witness herself. So the deposition had started early in the morning. We were hoping to fly back that late that afternoon, but we were there all day. So after the recess, we started back again. We started going through the documents, just polite, but plotting one by one through each. And I mean, we've been up late reviewing again, so they're fresh in our minds. We finished the deposition about 4 o'clock, and she stood up and she said, thank you very much, and she's very civil about everything, even though it had been difficult, and it's a contested matter. Litigation is adversarial and is unpleasant. She shook her hands and she said, it's been nice to meet you both, and I hope I never see either one of you again. Now, I'm not sure I can operate this device well enough to turn to the part that I want to raise. Among the quotes I've provided here, and we found at least one of my typos in this. It should say voice of vocation. I'll read this aloud. I hope you can see it. In our culture, we tend to gather information in ways that do not work very well when the source is the human soul. The soul is not responsive to subpoenas and cross-examination, and this witness had been subpoenaed and certainly was cross-examined. The soul speaks its truth only under quiet, inviting, and trustworthy conditions. Now, I bring this up because ultimately that case settled, and it settled after a mediation with the assistance and follow-up communications with the mediator. That dispute got resolved, as a very high percentage of disputes in civil cases are resolved in our court system. So, at the start, let's understand that we have in our system, our legal system, we have litigation. It is a confrontational, adversarial process that involves subpoenas and cross-examination and things that your lawyers and you have been through probably in some respect or are likely to go through. But mediation is different from that. Mediation occurs in a context where the parties have an opportunity using a neutral third party to come to an agreement. The mediator himself or herself has no decision-making authority and has no authority to decide a single issue other than to help schedule the mediation and the ministerial tasks like that. The mediator is trying to facilitate an agreement, which is almost the opposite of litigation. Litigation involves confrontation, attempting to win. One party generally thinks he or she wins, the other party thinks he or she has lost. Frankly, most parties lose in litigation because they're paying lawyers, they're taking risks, they're going through an unpleasant process, they're spending time that most parties, even business people, feel like is a terrible waste of time and is non-productive. Okay? Mediation works. The federal statistics some years ago suggested that in federal civil cases, as much as 80 or 85% of the cases were settled out of court, and many of them through mediation. Not always at the formal mediation. Sometimes there'll be a second follow-up mediation, or there might be follow-up discussions through the mediator, or built upon, even if it's direct contact, built upon the events of the mediation. Now, I've jumped ahead a little bit in our presentation. Just keep your hats on. I'm going to jump around a little bit. This stuff's a little dry, so we're going to try to spice it up a little bit, and I can't help it. Okay? You asked for this. I do appreciate the chance to be with you this morning, and at any point, if you have questions, you're welcome to ask them. I simply ask that we get a little bit into the presentation first, and some of the questions you have made already be addressed, but help me remember to repeat them, please. So let's backtrack briefly and talk about some definitions about mediation, arbitration, and negotiation. There are materials in your handout, I believe, that Ms. Briscoe pointed out to me that give definitions of these terms that are slightly different, and I think they come from an organization that you have an affiliation with. But if you read those definitions, they are in substance very similar to these definitions, which I took from a 1968 Black's Law Dictionary, which tells you how long I've been going at this time. Mediation, by definition, is intervention, interposition, the act of a third party who interferes, I don't like that term, but interferes between two contending parties, with a view to reconcile or persuade them to adjust or settle their dispute. So the mediator is a neutral intermediary seeking to help the parties find enough common ground to resolve their dispute. Arbitration, on the other hand, is much more like litigation, and more businesses are putting clauses in agreements when you, let's say, go to a nursing home or send a family member to a nursing home. It's not uncommon for those agreements to contain mandatory arbitration provisions. There are a number of cases litigating validity of those provisions and on what issues they are enforceable. There are other businesses that have mandatory arbitration clauses. Generally, in an arbitration, it's a contested matter where the arbitrator has decision-making authority, or the arbitrators do, akin to or similar to that of a court or a jury. So presentations are made in a similar fashion at the arbitration to those which would be made in court. Sometimes they're condensed, sometimes the proceedings are less formal, but then the arbitrators, for the most part, make a decision. Sometimes those, there are several different types of arbitration. There's compulsory arbitration, and there's arbitration that's not compulsory. Sometimes you're bound by the decisions, and sometimes they're merely advisory. But at the end of the day, the arbitrator has, or arbitrators have, decision-making authority. Am I doing something wrong?
Just change your location if it cuts out.
Yes, sir. I'll be wandering around, I'm nervous. So arbitration is different from a court proceeding, and the extent to which rules of evidence and those kinds of formal requirements apply might vary from arbitration to arbitration. But at the end of the day, it's more similar to litigation because someone else is making the decision. One of the pluses that mediation offers is if it works, the parties reach an agreement that has enough in it for each side that they're willing to accept it as a resolution of whatever dispute brought them there. You see the difference? Arbitration is the submission for determination of a disputed matter to private unofficial persons selected in a manner provided by law or by an agreement. So if you have an agreement with that nursing home that your loved one has gone into, that document might contain a mandatory arbitration agreement or some other less formal arbitration agreement. And then the matter would end up, if it were enforceable, being submitted to an arbitrator or a board of arbitrators. One of the difficulties is those arbitrators want to be paid. They expect to be paid just as your mediator is likely to expect to be paid. So in a court system, your tax dollars are paying for it for the most part, although there are filing fees and there are expenses and costs incurred. The court itself is not charging for its decision-making role. Finally, the term negotiation was one that we thought ought to be included here. The deliberate discussion or conference upon terms of a proposed agreement, the act of settling or arranging the terms and conditions of a bargain, sale, or other business transaction. We all negotiate every day at the yard sale down the street, in a variety of contexts. If you go buy a car, maybe some of you think there's not negotiation, but at some level there's negotiation. We negotiate every day. If you go buy a home or a piece of property, there's likely to be negotiation, and you know exactly what it is. It's the back and forth and the give and take, and there's always tension in what you're doing. If you do that lowball thing or make too high a demand, and I've seen it 1,000 times where people are trying to sell their home and they put a price on it that's too high, what happens? It just sits there and everybody walks away because the market will dictate to most purchasers who look at other properties, this is too expensive, it's out of line, or we can't afford it, or it doesn't match up with the other homes in the subdivision that we've looked at. So if an offer is made at all, what tends to happen is it will be way lower than that high asking price, and then all of a sudden what's happened is the parties are polarized and the seller's offended, and we're going to talk about some of that in a few minutes too, if any offer is made at all. Finally, the purpose of mediation in general is to help the parties resolve dispute on their own terms, okay? And that's sort of the magic part about mediation, and there is some magic to mediation. You'll see in the handout and some of the materials we're going to look at, that there's almost a spiritual quality. When I go to these seminars on mediation, I listen to some of these men and women speak about this. I went to Bridgeport, West Virginia, south of Monongalia County, a year or so ago to a seminar on this, and a woman from Baltimore does more collaborative mediation, which I can explain in a minute. But there is a spiritual quality that she is talking about in her presentation, because you're helping people solve problems, and it has a component that feels like that you're making for a peaceful world, more peaceful world. Mike Alloway, who's now a United States magistrate and has done an awful lot of mediation and speaks at the state bar seminars at Flatwoods on mediation. When you start looking at his materials, and some of these quotes that I have in your materials are taken from things that he dug up, there's a spiritual quality or a magical element in this process. It feels good for everybody when you get a dispute resolved in that. Who hasn't had a dispute with your spouse or your friend or your neighbor or somebody else, and you finally work it out, you feel like that burden is lifted from it. It gives you that sensation. If you win your lawsuit, or if you go to arbitration and you prevail, let's say your lawsuit and the jury or the court agrees with you, I'll move back here. And you make a substantial award. Do you know what we tell our clients? Well, you can expect an appeal, and then you're going to get another year or so before we're going to maybe have to come back and do this all again. Okay? Well, that isn't real appealing. Okay? So these are the basic terms that we're going to be talking about. There's a framework that we'll utilize, and I want to shift gears, unless you have questions where we are now. I'd like to shift gears and sort of give you an idea of how typical mediation in a civil case, I've mediated cases all over West Virginia, more as a lawyer than as a mediator, but hundreds and hundreds as a mediator, and more than that as a lawyer. Okay? I was in mediation in Morgantown for a case that arose out of Taylor County less than 90 days ago. Okay. You okay with my shifting gears a little bit here? Okay. Now, I cannot thank you enough for joining me today at this mediation. I've received the materials which your lawyers have submitted to me prior to the mediation we're conducting today. I appreciate your arriving on time. We'll have a brief joint session. There's coffee. There's some food if you need it. Why do we do that? Why do we do that? It eases tension and calms everybody down. Why at many church functions, at political rallies, and what is it about sitting down and eating together? It's our culture, but the little bit I know about the rest of the world, it's almost every culture, okay? So we don't always feed them, but if we expect a longer mediation as opposed to a condensed one, we'll certainly have coffee and water and usually some food, even if it's just light snacks. It's a little bit of a tension breaker, okay? And it's probably a cultural thing. I'm seeing more and more people do it. There's another selfish reason to do it, and that is if you run through lunch, which is fairly common, you don't get that sort of everybody ready to strangle each other at 2 o'clock as long as they get lunch. Okay? Yeah. Whatever started out angry is more angry, okay? So we would start out with a joint session where the parties are together most commonly. Now, I'm talking about civil stuff. There's mediation in divorce practice, and there's mediation in other contexts where there's such animosity or disparity of bargaining position or abuse that joint sessions, sometimes mediation itself is prohibited, okay? If you talk to people who do domestic practice, if there's domestic abuse, basically, it is my understanding, I used to do but no longer do domestic work, in West Virginia, it's very uncommon that there be mediation in an abuse situation. The reason is disparity of strength and disparity of bargaining power. That if one party's been physically abused, his or her life threatened, those sorts of things, then this whole process is out of kilter, and the court's going to have to deal with it rather than it being a fair negotiation. Before I go on about our mediation, I'll say, so mediation is done in domestic cases, it's done over custody issues, it's done over property issues, it's done in FINRA uses which is I can't come up with the right term for it, but it's done in brokerage transaction disputes for stock brokerage matters. It's a very common procedure done in all sorts of contexts, not just in civil practice in West Virginia. It's nationwide. It's very effective. So we're here in our little mediation. We've gotten our coffee, we've gotten our food, and usually people will be a little bit reluctant at first, but before that joint session's over, somebody will stand up and get some of the sweets over there, because we just can't resist that in this country. Serotonin. So, what will I tell them in that original session? It's just an orientation session. And I will say the same types of things that other mediators, whether it's Brown Hampstead, whether it's Pat Henry, whether it's Oscar Bean in Moorfield, whether it's Jim Lamp, who lives and practices in Huntington but grew up in Hedgesville, whoever that mediator is, whether it is the mediator in Baltimore who spoke at the Seminole and Bridgeport, there's usually a joint session where the process of how this works is discussed, okay? I try to keep my comments simple and short. I tell them, this is how this is going to work. I'm going to meet with both of you. I'm going to meet with you privately. You're going to each have an opportunity to speak now, but I warn you, this is a mediation and not a trial, and if you stand up and make an adversarial, confrontational, argumentative statement in this joint session, while we used to do it a lot, what we have learned is that it backfires. It's counterproductive because it polarizes the parties. Okay? So watch. This exhibit comes from a trial we had because the mediation failed, and shouldn't have, but it did. And the case involved a vehicular accident where a pedestrian who was flagging traffic was struck by a vehicle. You had an inattentive driver, and you had complex multi-party litigation. So we've sued the driver and some other folks we thought were responsible, and we're at the mediation, and I'm the lawyer for the decedent's family. They lost their son. They had lost their son in this accident. And so at the mediation, I didn't do this, I'm using it as an example. I stand up, and the driver who hit him and killed him in broad daylight pointed out and I said, this is your fault, you killed this child. The blame is yours. You are responsible, and the insurance company is going to have to pay every dime of the policy. And this company over here that was doing the road work is also responsible because they didn't put the proper signage up. The executive of the company is sitting there, and I'm shaking my finger at him, and I'm telling him everything they did wrong and threatening them and telling them we're going to get a multi-million-dollar judgment against them if they don't settle this. And this exhibit was prepared by our accident reconstructionist. Are we okay? By our accident reconstructionist. It's hard to see from here, But this is the point of possible perception 500 feet from impact. And so in my presentation, if I did it wrong, I would say to the company and the driver, from here he could have seen it. And if you'd had proper signs up, the driver would have been alerted and he would not have done this. So the company and the driver are at fault. Point of actual perception, when we know that he saw, because he started to apply his brakes, 109 feet, or 159 feet from impact. So there's a loss of about 350 feet because he didn't see, wasn't paying attention. Okay. And then there's skid marks that go across into the opposite lane when he finally realized he got his brakes applied. If I use this presentation in the mediation, what happens? There is no option for the other lawyers. What do? The defense lawyers.
You got to attack that?
Exactly. Okay. They come right back and they say, well, your man's down here looking, if he's paying attention, looking back the other way, and it's a 500-foot sight line the other way too. Why didn't he get out of the way? Now, how does that go down with the grieving parents? Okay. You think we're going to settle that case? It's over at that point. You might as well all go home. The likelihood, it's possible, but the likelihood of settlement is diminished. This doesn't have much to do with our topic. I just thought some visual aid wouldn't hurt today. Now, so what do we do instead? Okay, we have this joint session. You can say whatever you want. Counsel can talk, clients can talk. My suggestion is we keep this initial joint session civil, and every mediator I deal with today says a similar thing. And if you have things you want to share with me in a private session, do it then, please. Anything you want to tell me in the private sessions, once we break apart into caucuses, do it then. And the other side then doesn't hear that harsh attack and doesn't feel compelled. So those comments still get made to the mediator. Lots of times those exhibits have already been sent to the mediator in written submissions in advance. If you follow me, there'll be a mediation letter or mediation packet sent to the mediator in advance that the mediator studies so he or she has an understanding of the case. So that joint session, oftentimes today the lawyers say, no, we don't have anything to say, we'll talk to you in private session. We part company after 15 or 20 minutes at the most. Okay? Included in that joint session, I tell them I don't have any decision-making authority. I'm not in favor of one side or the other. I don't have anything to do with you, and I don't have anything to do with you. And if I did, I wouldn't have agreed to do this. If somebody's aware of a conflict of interest, you need to tell me, because I don't know of any. I'm neutral. But I want to help you get this problem solved. That's all I care about. Okay? If we reach a resolution, if I'm doing it, it's going to be written down, even if it's on a yellow sheet of paper, and signed by the parties and their counsel. We're going to have an agreement if we reach a resolution that will be signed at the conclusion of the mediation. Even if I went to Pittsburgh on a big insurance dispute a few years ago, it was Mother's Day, Sunday, and I said, Lynette, would you like to go to dinner in Pittsburgh on Mother's Day? And she said, what? I said, well, I have mediation Monday morning in Pittsburgh, so I'm going to be going to Pittsburgh Sunday. So off we went. We had a nice dinner. And then we did our mediation with a very seasoned Pittsburgh mediator, concluded a big insurance case, yellow sheet of paper, 3 paragraphs. X insurance company will pay to the plaintiff X dollars. The plaintiff will sign a release. The parties will enter a dismissal order. The parties will sign such further documents as are necessary to implement this settlement agreement. And they all sign it on a yellow sheet of paper. Job done. Okay? Got it? But you have a signed agreement. So, I talked to them a little bit, and I think it's beneficial to tell them how successful mediation is. Mediation works. Doesn't work 100% of the time, Doesn't always work at that session, but particularly if you're patient and keep working at it, it tends to bring about results in a large number of cases. Okay? So, let me see. Mediator's not a witness, and the mediation process is confidential, so I can't be subpoenaed to court to say, oh yeah, they admitted in the private session, party A admitted X or Y, or party B said something else. The mediator can't be made a witness. What goes on there is confidential. The mediator's not supposed to be talking about it, and the party shouldn't be talking about it. But part of the magic of this process is the free exchange of information. So if you tell the mediator, and your lawyer tells the mediator, count on it, the mediator may share some or all of that information with the other side, because that's how a lot of these disputes arise, because there's poor communication involved. If the mediator doesn't exchange the information, Mr. Sussman is shaking his head at me, you know, if the information is not exchanged, we'll never figure out what the problem is from one side's point of view, what the problem is from the other side's point of view. I've had them before where they said, well, I misunderstood. I thought X or Y. A misunderstanding based on poor communication or no communication. The exception to that rule is the parties are instructed to wave a red flag if they have something they want to share with the mediator that they do not want shared with the other side. Say so, the mediator will honor that request. I want you to know this, but I don't want you to tell them, or we're going to try to drop this bomb on the trial, but you ought to factor it in, or whatever the issue might be. I can't afford to go to trial. I have to get this done today. You certainly don't want to tell the other side that. Okay? But you might tell the mediator in confidence. Okay? It has to be made clear. Yes, sir.
Would you ever try to talk that party out of that stand?
What's
They
the
don't want
question?
the other side to know?
The question is, would you ever try to talk the other party out of that stand? Okay? Do you mean the stand, which
They want it to be kept confidential, where you think it's important that it get out.
once in a while, and you have to be careful about that, and I'll explain why, but the answer is yes, once in a while we do, okay? My goal and the party's goals are different. There's some similarities. Most parties want the problem settled. That's all the mediator cares about. Mediator wants problem settled. There's one other thing, and that's payment, but you've already taken that risk, okay? So what this question goes to is another point in our presentation that I want to bring up. Mediators traditionally enter disputes with little authority, so their ability to help bring about settlement depends in part upon the willingness of the parties to accept the mediator. Mediators typically gain this acceptance by earning the parties' trust. Okay, I won't read the rest of it yet. If this comes up in a context or a time when trying to talk the person out of it might undermine my efforts to gain trust, the answer is I would not try to do so. A fair amount of the early discussion in mediation by the best mediators involves listening, and you will see the good ones ignore the lawyers and turn to the clients and start asking them questions. Why? They already got the written materials. Why are they doing this?
They want to see where the people are actually coming from.
They want to see where the people are actually coming from, what other reasons, what psychological or subconscious reasons might be involved in doing this. What do you want? You want the parties to have a chance to voice or vent the problem in their own terms, not hamstrung by a lawyer who won't let them speak, okay? You want them to get it off their chests. And part of the magic of this process will be lost if you don't listen to whatever the concern is or the position is and give credence to it sincerely and think it through, and then give yourself a few minutes or hours to figure out how you can address that, even if it's a serious obstacle to mediation. You got to run it through the process and think about it and listen to that party. The best mediators, they'll look you dead in the eye. They will look the parties dead in the eye, and they will listen as if they are entranced, whether they are bored stiff or not. Okay? It makes perfect sense. You know, you want to know when my wife gets maddest at me?
When you don't listen.
When I don't listen. If I have that laptop and I'm looking at fishing tackle or the golf equipment or, you know, whatever else it might be, and that's about the worst I do, and she's trying to tell me what happened this afternoon, and this has happened 25 times in all these years. And I have to hear the story about this again. I need to put that laptop down, and I need to listen to her like it was our first date, okay?
That's right. The other thing about that too is that you get a sense for what the other person's passionate about. And it may not be the brilliant legal argument that actually will control, but what they really care about.
I don't know if you could hear it, the point's very well made. You get a sense of what the other person is passionate about, what they really care about, and most of the time it's not the brilliant legal argument. Many times it's not. But you find out what the soul, we were talking about the soul, what's at the heart of this thing? What's really driving this dispute? There are materials that I have, I'm not sure I include them, where a simple apology, and the lady from Baltimore said in her collaborative mediation, she's had cases that could have been worth millions of dollars settled for next to nothing because the other party apologized. Okay? A good example of what you're talking about. The other parties agree. Yes, sir.
A lot of times, it's just that the other party is trying to work it through their mind as to what the situation is, and instead of just telling the story, they're trying to work it in their mind and get it right what they want to do and say.
I heard that well. I hope you did. His point's, again, well made. The other party's trying to work it through to understand, and each party is trying to do that. And if the parties are wise, they will include in the mediation to learn from the mediator about what the other party's position is. So your point's excellent. Could everybody hear it? Okay. Now, so we've concluded in our little joint session here discussed. We've concluded our joint session. Unless somebody else has something to say, and usually today the lawyers will simply say, we don't have an opening, we appreciate the chance to be here, thank you for working with us. How did we get here? Either the judge appointed the mediator or the parties agreed on the mediator, state court, federal court, that's most common. And my experience is with the court system, my experience is not, it is limited. Although I've used mediation to resolve disputes outside the court system, very rarely do I see it happen. I think it's a great idea for organizations like yours, if you have a dispute, to say, listen, we have a dispute with a member, or maybe between a board and a member, or between members. We have a dispute. There are mediators in our area who help parties resolve dispute. How would the parties feel about employing a mediator? And there might be some who do without fee. I don't know. Most people are trying to make a living doing this. How would the parties feel about having an agreed mediation? And there are ways to keep the cost down. You don't have to mediate for 3 days. You can mediate for a half day. The mediator already has the written materials. You can condense things and mediate from 8 to 12 or 1 to 5, and the expense has limits on it because of the time involved, okay? I think it's a good way to try to address disputes, you don't want to send every dispute to mediation, but if it's something, and you could do pre-suit mediation, if somebody's threatening a lawsuit, you might suggest, well, we don't want to have a lawsuit, we don't want you to spend the money, we're all neighbors here, we're all in the same community, and when this dispute's over, hopefully we'll all still be here living together, walking our dogs down the street together. Yes.
Could you do something like that in the bylaws?
I don't know why you couldn't impose, I don't know the absolute, I'm not an expert in the Homeowners Association law or the Common Interest Ownership Act or any of that. I've dealt with it, but I'm not no expert in it. Absent some prohibition, I don't know why you couldn't pass, in accordance with your bylaws and your declarations, why you couldn't pass a requirement to mediate.
Could we refer that to Bob or Nan?
Well,
You might?
the issue is a conflict. If your declaration states you must go to arbitration, arbitration, I think, Sam, trumps mediation, because it's at the lower. So if you put in your bylaws that you have to go to mediation first to resolve an issue, I don't know if that is in conflict with.
You could do a step process.
Right. So Sam, it's a grab bag on that one, because mediation and arbitration, we've got two very powerful but different issues.
And yes, ma'am.
I think this is where the state is very neglectful, because we're all common citizens. And I can tell you right now, I will never be president of a community again. And ours is very small. I've learned a lot about myself through bullies in the community, and I've learned how to back off and treat them by having it discussed at an annual meeting. I mean, we don't have monthly meetings, but I will never do this again. I was brought to my knees, but I'm glad, because now I just step back and say, have at it. Waste your time. Give me 3 points to work. This is my brain. Give me 3 points to work with, and I'll discuss it at an annual meeting. Unfortunately, we live in a subdivision that has a homeowners association and bylaws. We've all seen it. If you're in a homeowners association, you've seen it. Okay. So, I mean, I said before, the people who are willing to serve on this board they're angels. But for the most part, once in a while you get a power-hungry person who just wants to run the show. But for the most part, they're angels willing to give their time for little or no compensation, give up their evening, give up their time to try to work for the organization. And I'm assuming that's for the most part who we have here. And I think the state is neglectful on that point.
And the developers are, as somebody said before we started, not all of them, but for the most part, they write these bylaws because they have to. They write the declarations because they have to. And as soon as they can step away and leave the mess for the homeowners to deal with, that's what they want to do. I understand that, they're running a business, I understand that, but there's a valid point that, and what happens is people tend not to want to serve after seeing some of that, okay?
Sam,
Yes, sir.
we will be touching on policies for conflict resolution that an HOA can do when we have the open discussion at the end of the meeting.
Cool.
So now our joint session is over. We're ready to break into separate groups and have what we call private caucuses. There'll be, grab something to eat, take a bathroom break. By the way, the most important thing we tell them is where the bathroom is. And it's back there, and people get grumpy, okay, they get grumpy, no food, no bathroom, they get irritable, and part of the objective here is keep everybody really calm, so we're trying to be. Humor is an effective tool. I don't have to tell anybody in this room. And you know, more than once, if I sense that I can tell a story that is humorous without offending, I will try to do that. And sometimes not in that joint session, But once I get them privately, and I'm with them privately, I'll use that tool, and I've seen other mediators use that tool. In addition to listening, if you can tell a little story, making fun of yourself or making fun of something that happened, and they start chuckling with you and they see your humanity, it works. Okay, we've all seen it, we know it works, and it works in this context that was brought up about bullying and that kind of thing. It's very disarming sometimes if you can use those sorts of tools, particularly in a mediation context. So after that initial session, there are joint sessions. So you go sit down with people privately as the mediator, and somebody's put up a fence in the neighborhood or built a garage that doesn't comply or an outbuilding or whatever the issue might be, and there's a dispute with the board and we're mediating over this silly thing. It should have been cleared through the architectural committee or whatever the problem is. Let them unload it. The mediator is not doing exactly what the parties might think. The parties think they're advocating for their cause. The mediator's over here learning about the cause, but as you've already observed, trying to find out what the real problem is. So you'll see the mediators who know what they're doing. They'll include the lawyers, but they want to hear from the parties. They want to hear what the real rub is, not the slick legal argument that might or might not persuade a court. They want to hear, what's wrong here? What's wrong is this guy throws his beer bottles over in my yard, okay? But we're really fighting about something else, and what's happened is the beer bottle tossing has gotten masked under this dispute over the garage or over the fence or whatever else, okay? We had one in our subdivision, and I don't know the status of it, I'm not involved, but it actually involved a fence that was built, and it was high and probably violated the covenants, and once there was a challenge to it and it prevailed, the problem escalated to the point that one party's moved. Okay, there were criminal charges filed, it just got way out of control too quickly. Okay, now, let's pause. If you have questions, you've asked some, but if you have other questions, we'll pause while we go to our separate rooms, and then we'll continue our discussion about how this works. Anybody have a question about, yes ma'am?
When you have two homeowners in the same HOA, and the board cannot get the two homeowners to level up, can the board call a mediator and say, come and take care of this? Or is the board looked at as being involved themselves?
One of the challenges of questions like this, and it's a great question, but it's being asked in a vacuum without a set of bylaws, without a set of declarations. And so for most of you all know this, for most of your questions, I would immediately go to those documents, okay? I doubt they're going to address that issue, okay? So the answer to me is, if those documents do not address it, that the board certainly has the right to make suggestions to these parties, but I don't think the board would necessarily have any power to compel the parties to do mediation. If they want to have a knockdown, drag out, physical or legal fight, the board probably doesn't have any power over it, absent something in the controlling documents that would permit that.
All the governing documents have a, I don't know what you call it, an implied clause that you're going to be civil, that you're part of the HOA, that you're not going to be the mean, bad, ugly person, because everybody has a right to civility. So the board oftentimes is contacted by homeowners on the periphery saying, these two people, you got to do something about it. It's disrupting our community. So with the fiduciary responsibility of the board trying to follow the civility implication of the governing documents, they feel they need to go get someone to stop it or settle it.
There's no expectation of civility. I don't think there is under any.
Well, certainly not, if we turn on our intelligence sets, we understand that's long gone, common courtesy is out the window here.
That's just, the law has never expected civility. That's why you have detailed rules. Unless it's criminal.
Well, and I would say to you, you're even going to have, and I've seen this, where somebody will call the police, and the police will come out, and until there's a crime committed, and there's sufficient evidence that they can file charges against somebody.
Or civil assault.
Sure, and that would be an example. Not a crime, but a civil assault. So these problems are going to arise. My thought is that the association has a darned if you do and a darned if you don't problem at that point. If you intermeddle and you step into it, all of a sudden what was a two-way dispute is a three-way dispute, and I thought, unstudied, and I haven't seen any documents, don't know the detail, but I would say to you, at best, I would be very careful and might say, listen, we understand there's a problem, and we've had some work with mediators and know about the mediation process, and maybe this would help resolve this problem. But again, I'd be very careful about interjecting. I don't know what Richard's nodding his head, he thinks so too, so that's my reaction, yes.
How do you get a mediator without lawyers?
Well,
We just went through that process, and we had lawyers, and they were the ones that suggested mediation, which worked out great, but can you go personally to a mediator and say, hey, come over here?
actually you can't. And the state bar has on its the West Virginia State Bar has on its website a list of licensed mediators, trained mediators. And I brought materials from the West Virginia State Bar basic mediation training that latest I could find was July 21 of 2016. And these materials I found online. It wasn't anything brilliant that I did to find these. I just Googled mediation training in West Virginia, and this stuff popped up. I did not duplicate all this for you. But the West Virginia State Bar has that. And then you can go on their website and find a list of trained mediators, and there are some of the people I mentioned to you. Yes.
So if you get two parties to agree to mediation, do they sign an agreement that they will implement whatever the final result of mediation is? And is that binding, or is it still everybody's got to agree? Can you make them in the mediation agreement say they will stick with whatever is the result?
Generally, at the end, yes, if they sign it. That is the reason.
But they can walk away and not sign anything.
They can walk, and often do. Sometimes mediations are unsuccessful. What we've learned is sometimes not all the information is available, or somebody needs to talk to their insurance company, or they need to talk to their lawyer, or they need to talk to their spouse, or they need to sleep on it. And so we often do either follow-up telephonic communication. Still, then, if we reach an agreement, we fax it around, everybody signs the thing, or email it today, but at the end of the day, the agreement, and I've been involved in some enforcement actions where people sign an agreement and then try to backpedal away from it afterward. But that's exactly why we reduce it to right, okay?
I think the statement that was made about there is no expectation of civility unless it is criminal, the treasurer and our association went to a lawyer because this contentious homeowner said if people don't slow down on our road, I'm going to throw 2x4s. Now the lawyer said, the moment he does that, you are all responsible for anyone having an accident, and it still gives me chills. So that was a starting point for us. But please, write that statement down, because the state of West Virginia will make your community liable for any accident that's caused by someone putting an unsafe situation, whatever. Ours happens to be roads, but whatever.
Even if there's a tree that maybe
No,
is
no.
taking away from the
Well,
site
unless
of
the person cut it down. You know, I mean, really,
friend.
really, that's a great statement, and if you just keep it in the back of your mind, on your board, it's very wonderful.
Would you repeat that statement one more time? The one
Well, it's
you
what
talked
this
about?
gentleman said, there is no expectation of civility unless it is criminal.
Or
So-
the second half of that, or civil assault, because you can have assault that is not criminal.
Right, but like this lady's example, I said, if,
You gotta speak louder. This is being
or if the tree falls naturally onto the road and someone has an accident, no. But if you have someone who cuts a tree hoping it will fall, and they see that it's a cut, then the community is liable.
How about if the tree is growing to where now it's out of their area, it's growing onto where it's.
You were talking about an incident of an accident,
Yeah. And it caused
criminal.
an
Right.
Anything, so it would have caused an accident just growing larger than it should.
Right.
And taken away from the site of a roadway. It still would be, HOA would be.
You would have to remember what is the criminal.
Every one of these instances will be different, and
Yeah.
I mean, we've had litigation in our homeowners association when a pool was installed and it infringed on some setback lines, and there was litigation over it. And, I mean, there never was, I don't know how it got resolved, there never was what I would call any peace with reference to problem. There was always animus after that. The board resented the homeowner building within the setback, the homeowner's going, what the heck difference did it make? It's a minor infringement of some sort or another, didn't do anybody any harm. And there are a lot of those types of disputes in this context. There's one going on now that I know about that involves a paint color issue, okay? You know, we're at a hospice facility, and when I pulled up here, I thought about it, and I thought, you know, thinking about the spirituality issue and thinking about what some of these people have said, our lives are short. Our lives are short. All of our parents and our family are dead. We're here for a short time. And I make my living in these disputes, believe me, I don't mind the disputes. On the other hand, you know, what is it we're going to fight over and that we can't get worked out on civil terms? And what is it that requires, and hope, you know, some people have them, they just want to fight, or they want to bully, or they want control. Sometimes, and I will tell one story on this issue, sometimes the problem has nothing to do with what's going on. I had a closing many years ago, and a childhood friend of mine had sold a piece of property, and I was doing the closing. No, I can't remember. Yeah, and the purchaser objected to every page on every document, the closing, everything. And finally, we were 2 hours into what should have been a 30-minute closing. I said, I have an idea. The bank sent me this loan package. I'm following their instructions. Let's get the bank officer you work with on the phone, and you can work out with him. I don't care what the documents say, as long as the bank's happy. Okay. We finished the matter after about 3 hours, got it all worked out, sent out the door, and my childhood friend looks at me and she says, I don't know how you stood it. And I said, well, I was about ready not to stand it. She said, he was impossible. And I said, well, we get all kinds here, you know, the doors are open, we get the great folks and we get them not so easy to work with them. Well, years later, I learned that person had lost a child. Had lost a child sometime not too long before. What I believe, and I have very little training in any psychological matter, but I think we all understand something about human nature, is that the grief and the anguish and the anger, there was never going to be anything right in the world at any point on any subject in this policy. Okay? And it got played out in a strange context. Okay? So as you're dealing with people in your communities, what I would say to you is somebody who's done a lot of mediation as a lawyer and a fair amount as a mediator, try to remember what's behind this angry, tyrannical, difficult person may not be what it appears to be. Okay?
But the key there is that you didn't let that person drag you under.
I got pretty close. I got pretty close. So trying to keep, and I would say this to the board, trying to keep your composure. And I'm going to turn some of our materials. We'll probably get near a break, and I'm not, it's up to you all when we do the break. And Tom Patrick was a professor, I think now retired, at West Virginia University College of Law, and he's done a lot of speaking, a lot of training, a lot of implementation of mediation in the court system. And Professor Patrick points out that there are 4 broad sections to typical mediations: orientation, which we just talked about in our first part; information, which is we get into the rooms and we're sharing information and obtaining information; option. What are the options here for the parties? What are the choices? What are the alternatives that the parties might use to come up with a solution? We're going to go back to our situation. What are the alternatives we might use in dealing with this difficult homeowner or this challenging problem? Mediation is one. You can do an informal mediation where the board might say, look, we don't have authority to do it, but we'll see if we can get volunteers to sit down with you all and talk this problem over. We'll get a pot of coffee and we'll get some iced tea and we'll get some sandwiches. We'll all have lunch. And what am I doing? I'm running right back into that cultural safety zone. Okay? I'm running right back in there. Let's talk this problem over and figure out what we can do to help the parties. Do you need a fence between you? Do you need it? What do you need? Okay, I don't know. I'm throwing ideas at you. So he says, stage 3 is options. You can't talk about options with parties in a dispute until you have gained their
Trust.
okay.
What was the right answer?
Trust. Okay? You have to have, they're never going to trust you entirely, okay? They're going to read every spot on that yellow piece of paper, okay? But until they have confidence, you're not trying to sandbag them and help the other side, right? Until you have confidence that they are, I thought we were going to have a drink. It being near St. Patrick's Day, it occurred to me that Irish coffee would make the meeting interesting. Yes. So until you have that confidence and you have some trust, that is, the mediator has established. And how's it done? You know, we make assessments of people like that. There's just something I like about that guy. There is something about her that rubs me the wrong way. Within minutes we do these things. So you got to be careful when you're a mediator. If you're listening and you're asking Jim questions about the problem, and you say, oh, I understand. I see now, how does that make you feel? You're drawing them out, and they get a chance to unload their problem on you. The odds go way up that they may not want you to come over for dinner, okay? But they probably aren't going to say, I hope I never see you again, like the witness did that had been cross-examined for 7 hours, okay? So Professor Patrick has simplified this. There are other outlines I found. This is online, you can find it, but this is a 6-point outline of similar points. It's in your materials. It talks about planning, where are we going to do this, how are we going to proceed. We send out, and all the lawyers who do this send a mediation letter once they're asked to do it, here are the terms we're going to proceed on, you're going to pay me X dollars an hour, we're going to have mediation on such and such a date, you're going to submit written information to me 24, 48 hours in advance, we're going to all meet at 10 o'clock at such and such a place. I'm not aware of any conflict of interest, do you know any conflict of interest? So there's a letter sent out explaining who attends, where attends. You have to have people with authority at the mediation. It doesn't do any good in a car wreck case if the insurance company that's going to write the check to settle the claim doesn't send a representative with the authority to make a decision. Okay? Mediator's introduction, opening remarks, you give your reviews about all this. We used to do it. We used to stand up and make these opening statements like I said to you, and finally somebody, it dawned on somebody, this is not working. Okay. Joint discussion, well, this outline, and I'm going to speak briefly about collaborative mediation. I've been through this a few times. The speaker from Baltimore has a very open view about mediation and uses a much more collaborative model where the parties tend to stay in the same room through the whole process. She's drawn them out to speak to each other about how they feel about these things, what is bothering you about what's being said. Here in West Virginia, you're just hoping somebody doesn't pull out a gun, okay? That's a joke. I'm not saying that truly. I'm telling you, I do not, there is a grain of truth to it. I believe that process, which she believes in and has used to tremendous success, depends upon the nature of the dispute, and it depends upon the mediator. This is a highly skilled, very sophisticated mediator with a national practice, and she's flying Los Angeles to work on disputes. They haven't invited me out there yet.
Sam, I think it's about time to take a break.
We're ready to take a break, and I apologize if I'm rambling a bit. Okay. So, what was that thought?
Collaborative mediator,
So
very
the-
experienced.
So, I suspect that she could conduct a mediation with the same dispute, the same parties that I would do, or Richard would do, or Pat Henry or Oscar Lee would do. And we would tend to do it in the more traditional manner. She would tend to do it in a more collaborative, cooperative fashion. She'd probably do fine because she's comfortable with it, experienced with it, and willing to handle it in that fashion. It's not how I've learned to do this. It's not how I've been trained to do this. It's not dramatically different. I've also seen it blow up where you have parties highly antagonistic in a family dispute, and we had a collaborative mediation, and before it's similar in my mind, or can be, to that problem of making openings in front of each other, where there's a tendency to be very defensive and very adversarial. All right, so we're following some of our primary rules. We had a bathroom break, we got a little food, maybe a little coffee. Nobody's too irritable. Let me tell you how much I appreciate, again, the chance to share some ideas with you. I'll give you a disclaimer that none of this is legal advice and none of this is etched in stone. All we're doing today is having a general discussion that has to do with kind of how mediation works, the differences between mediation and arbitration, what mediation can do. Sometimes it might be applicable for you in the context of your homeowners association. Richard Sussman, who's a local lawyer I've worked with before, had some thoughts that he shared with me during the break, and I wanted to give him an opportunity to comment on some of what we've been talking about. I thought his ideas were real good.
Thank you, Sam. Just to be real quick, remember, part of the American jurisprudence, the fundamental right to access the courts, unfortunately, it's a very adversarial system, and it disregards emotions. But what we're here to talk about is resolving disputes, resolving resolutions, alternative dispute resolution, something other than the court system. So, to answer some of the earlier questions, when it comes to can the association force arbitration or mediation? Without giving legal advice, only if your covenants list it as a requirement. Because the fundamental right to access the legal courts is part of, the entire U.S. legal system. It takes quite a bit to alter that right, to hinder it or to change it. So when we agree to purchase a home in a planned unit development, with all those rules that are recorded against the land, regardless of who the owner is, if the covenants say there's mandatory, whether it's binding or non-binding, arbitration or mediation, then and only then can the association force that process. But again, we're trying to get away from the adversarial approach. So if we can voluntarily get the parties, whether it's two neighbors against each other, a neighbor against the association, or board members against each other, if we can voluntarily get them to agree to that, once we can get to that point, then we can have a real resolution that can address the parties' feelings, emotions, their principles, which may have nothing to do with the law. So a good resource would be getting to yes without giving in, and the author's name is Roger Fisher. But yeah, the whole point is trying to get to resolution. So instead of trying to think about, okay, we have to enforce the covenants, think about alternative ways of trying to listen to, most important skill, listening to the homeowner, why there's an issue. Their husband or wife is sick and cancer. They haven't been able to maintain their property. Do you need some help? If you don't have that communication, you might not know, and it feels adversarial. They're just getting a cold letter or a knock on a door, and then they blow up because you said something that you had no clue about, but it offended them. Emotions may have nothing to do with the covenants or the law, but getting to that point is the key of mediation.
Would you repeat the name of the book?
Getting to Yes Without Giving In by Robert Fisher.
You said Roger first. Okay.
Let me make sure.
Roger Parker?
Roger Fisher, yes. Thank you, Sam. Oh, I forgot. Sorry. I forgot the other question.
Keep talking.
In the West Virginia Uniform Common Interest Ownership Act, Chapter 36B, if you search the terms arbitration, mediation, dispute, and resolution, you will get 0 results for each of those terms. So draw your own conclusion.
Okay, well, maybe the legislature needs to add a few words to the Common Interest Ownership Act. During the break, one of your members asked me about experience in Texas and Louisiana, and I was a young lawyer when I know you can't tell, but it's been a while since I was a young lawyer. I was a young lawyer when I had worked down there, and this story has nothing to do with anything, but I'm going to tell it anyway because I have the microphone. So, and this tells you something about people have something on their mind, okay, then you got to listen. So, we had a young family, and I had to go down there a lot, and we had 3 children in 2 years, had a set of twins. There were days I would come home and my poor wife would not have gotten out of her bedclothes, would not have showered, or brushed her teeth. And I mean, this was a bit much. You've all lived through similar experiences. You know what I'm talking about. So I had to go to New Orleans or Houston one time, early when I was young. And to get down there, I tried to leave early in the morning. We lived in Charleston at the time, and I'd get up early and get a morning flight, and then I could get down there. There was an hour's time difference in Houston, and I could be down there by 11 o'clock. So instead of running the whole prior day, I'd get up early and get the earliest flight and get. Oftentimes it was dark, and so I'd get my clothes out the night before and get my bag packed, and everything's organized, and I try not to wake the children up, and I try to let my next sleep, and of course she had almost no sleep during those years. And I'm on my flight, everything's going lickety-split, I carried the bag so I didn't have to check it, I mean, I had this figured out. So I had my coffee on the plane, I had some at home, and of course I needed the bathroom break. I got up, and I went to the little bathroom on the plane, and you've all probably had this unpleasant experience. If you're in there like this, I had my boxer shorts on backwards. What does that have to do with what we're talking about?
So that was no,
The best laid plans of mice and men. It doesn't always go as you plan. There's a lot of uncertainty in life. Don't lose your humanity. And it's one thing that doing these mediations will remind you also. And Richard's talking about this when he says these things to you. Don't lose your humanity in this process. Why did you laugh? You laugh because it's a common experience that we have things like that happen to us. And if we're so worried about a stain on our suit or a car being waxed or our home being perfect or whatever, does it really matter that much that my neighbor wants to put up a fence that I don't like, but that might not violate the covenants, that I'm going to declare war and there's going to be a big to-do in the Homeowners Association? Let me just tell you, with my neighbor, when the snow flies and I'm out there struggling with it, he is right beside me. He's right beside me, okay? We go over and do his, and then we go down the street and do some other neighbors, okay? To me, that's a lot more valuable and valuable to the community, okay, than seeing that we have literal enforcement of the covenants and that sort of thing. Okay, let's go back, and I want to read to you, or review with you. I'll try not to read too much to you. More on trust. We can get to the second paragraph, which is really what we're talking about. Trust is attained and maintained when the mediator is perceived by the disputants as an individual who understands and cares about the parties and their disputes, has the skill to guide them, to negotiate settlement, treats them impartially, is honest, will protect each party from being hurt during mediation by the other's aggressiveness or their own perceived inadequacies, has no interests that conflict with helping to bring about a resolution which is in the party's interest. Only when trust has been established can the parties be expected to be candid with the mediator, disclose their real interests, and value the mediator's reactions. Okay? I don't think that's anything you didn't know before we looked at it, but I want to make sure it's touched on. Related to that, I want you to understand something. As the mediation process goes forward, you listen, you listen, you listen, you listen. Look at this one. This one involves a change, a different point. The mediator is also the agent of reality. This is one of the mediator's most critical roles. As agreement or its possibility nears, your job is to increase awareness by each party of the other party's needs and to help build a realistic framework within which the parties can assess the costs and benefits of either continuing or resolving the conflict. In this role, you risk suffering the fate of the king's messenger. Don't kill the messenger, we all know that one. Of the king's messenger. This is an unavoidable risk. Most times the mediator is the only person in a posture to take the risk. Okay? In other words, I might have to say to the association president, you know, your covenant isn't really very well written, and I'm having trouble understanding that it absolutely clearly prohibits what the homeowner's doing. I don't say that at the beginning, even if I have it in my mind. I have who have gained confidence before, long before, and have some trust relationship. And to the homeowner, so you have a home that you spent $100,000 for, and you're gonna have a dispute that's gonna go through a court system, and you're gonna spend 20 grand fighting with the home agent of reality, okay? No one likes to hear it. The mediator's in a position to do that, usually late in the mediation, okay? Let's see here. A couple other things. Court rules, I included a bunch of court rules and they're not even typed right. That's on me. My secretary didn't make that blunder. I did. I take full responsibility. And we'll straighten those out.
What's not right, Byron?
There are some typos and omissions, so we'll fix those. They're not major. I can show you some of them, but we'll fix those. I tried to quote from our West Virginia trial court rules that govern mediation. Most of the principles we've already talked about, but we'll look briefly at those and then we're almost finished, okay?
Sam?
Yes, sir.
To that point, when I asked earlier about could we put mediation in the covenants and the bylaws, I was planning on using these as some sort of baseline and even stealing a lot of the concepts and basic ideas from them. So are we going to get these corrected on the record copy at the website or what?
We will get them corrected on the website. I will, if you like, provide corrected copies to be sure they're accurate, which you can get at your next meeting if you want to, or however you would transmit that. We'll work that out.
If the citations are correct, we can get them online, right?
Probably. The citations, I think, are correct.
Okay.
These trial court rules apply in state court proceedings and circuit court.
Right.
Okay?
We can impute that there's some sort of general consensus under West Virginia guidelines that this is a logical way to do mediation.
No question about it. Okay? You can also find local rules for the federal district court for the northern district. We're in the northern district here, and I think everyone, at least to Clarksburg, south of Clarksburg is the southern district of West Virginia. I gave you a citation to the northern district and southern district federal rules. I didn't quote them. They're very similar. They're parallel. They're not identical to these state court rules. So the mediation rules from the West Virginia trial court rules, they give you a definition of mediation. We already looked at a definition of mediation. This is a little more detailed. They give you, this says section of cases for mediation. It should say selection of cases for mediation. That's an example of our typos. Listing of mediators. State Bar shall make available on its website list of mediators, so it's referenced here in Trial Court Rule 25.04. Selection of mediator, and this is how mediator is selected if you have a court case in state court. Compensation, you need to be careful when you get involved with these mediators. They want to be paid, okay? Mediator disqualification, it's important the mediator is somebody you trust. I have an article that I brought with me, written by a plaintiff's lawyer. He sues people in car wreck cases and medical malpractice cases and that kind of thing. His article says, very seasoned lawyer, you would think you would want a plaintiff-oriented mediator to conduct your mediation. Au contraire. He says, and I can pull the article. He's talking about catastrophic injury cases where you have a paralyzed child or a profoundly injured person. You might think a pro-plaintiff mediator is an advantage, but it is not. Assuming the defense lawyer is willing to use an untested mediator, the scent of bias can permeate a room pretty quickly. So What it does, and you already understand this, is it undermines the trust. If the insurance company or the defendant gets the feeling that the mediator is biased, forget mediation ain't gonna work. So he says, in effect, you're better off having a pro-defense mediator and factoring that into what you're doing so that the defense trusts him, the insurance company or whoever's on the other side. What you really want is somebody who doesn't have a stake in the thing. Mediator disqualification, again, it has to do with having a bias. This is pretty detailed, it goes through the examples, but if you're related to anybody or you have some business relationship with them and that kind of thing. Frankly, I disclose even distant relationships of any sort, and the effect is the other side almost always, it's the trust thing again, because I've disclosed it, they said, we don't care. All of a sudden, they tend to believe you're trustworthy because you have told them. If you don't tell them and they find out halfway through the mediation, guess what happens then? Forget it, okay? I'm not giving legal advice today. Every situation is different. You've all got different bylaws. All the circumstances are different. There are a couple of articles that I've referred to that are mainly from the state bar materials today. And I want to back up and conclude this, though I'll answer questions or be happy to share ideas and thoughts with you. Just bear with me a second. Okay, so without being too sentimental about this, let's think about what we're talking about. This is a great truth, one of the greatest truths. The first of the four noble truths which Buddha taught us was life is suffering. What makes life difficult is that the process of confronting and solving problems is painful. Yet it is the whole process of meeting and solving problems that life has its meaning. Problems are the cutting edge that distinguishes between success and failure. Problems call forth our courage, they call forth our wisdom. They create our courage and wisdom. It is only because of problems that we grow mentally and spiritually. Now, I'll close on this quotation because I think it's helpful for your organizations to think of this. You have, if you're on your board or are active in your association, agreed not to sit there and drink the coffee and eat the donuts and ignore the problems and wish they weren't there. You have assumed the mantle of one of the noblest callings of helping to confront and solve human problems. Okay? Mediation is a tool which you might use, and I hope the presentation has been helpful to you in that regard. I can't thank you enough for the chance to share these thoughts with the West Virginia Association, with the West Virginia Organization of Homeowners Associations. Thanks, everyone.